I'm going off video, folks, but I'm here.
Hi, Chris.
Hi.
Right. Oh, here we go. We've got some more people coming in, but we'll get started in the interest of time. Hi, everyone. I'm Helen French. I'm the Director of Development and Continuing Education at NASW, New Jersey. So pleased that you're joining us for our fourth and final community conversation with our friends at ASI Insurance, which we really appreciate their sponsorship and expertise. So just a bit of housekeeping. When you signed up for this webinar, you agreed to a code of conduct. We expect you to be respectful to the presenters and each other. So without further ado, Phil or Dina, who's going first?
I think Phil nominated me too. Good morning, good afternoon, everybody. It's still morning where I am. For those of you who are seeing me for the first time, my name is Dina Lawson. I'm a senior risk analyst with GB Healthcare, and we partner with NASW Risk Retention Group who monitor the professional liability claims and risk management questions that you all submit. I personally oversee the hotline, and so I see all of the questions that come in, and certainly enjoy visiting with all of you. So with that, Phil, introduce yourself and we'll get going.
Yeah, hi everybody. I'm Phil Lawson. I'm Vice President of Product Development and Risk here at the Risk Retention Group. And you know, I manage all the claims with the help of our adjudication outsourced company, Gallagher Barrett, where Dina works. And I've been able to, for the last 9 years, I've been doing this, and I've been able to learn from our claims experience how good our products are, and also add additional benefits to our products to handle some of these claims and incidences that our members get. So it's good to be able to look at the claim side and then product modification and product development side.
Okay, so with that, let's talk about divorce. Divorce mediation may be a little bit of a misnomer. I tend to think of it more as divorce, how to survive it, and not necessarily your own. But if you are working with someone, whether it's an individual, whether it's a couple trying to keep things pulled together, whether it is a child whose parents are going through a divorce, handling all of that is a handful of sweating dynamite. I'm not going to lie. It can be a challenge. It can be navigated, and you can come out on the other side with a whole lot of lessons learned that you will take forward to your next clients as you come into this situation again. But there are a few things that I think you need to remember as you're starting to deal with anybody who is being touched by divorce. Even if it's just separation, if it's actual, they're going through the process of divorce, or they've come through the divorce and now we're battling over custody, or we're looking at custody again, and which is usually where all of this mess seems to happen. So how do you survive this? There's four things I think that are really important in order for you to survive this. And Phil, please, if you think of things, please feel free to jump in here. Number one, you need to understand that your notes are not sacred. You need to understand that up front. Yes, your notes are confidential, but at the end of the day, if there's a judge who says you will give up your records, no matter how badly you want to protect them, you will give up the records. The consequences for not can be painful, and we'll go into that in a little bit. Number two, You will most likely wind up being drawn into their court proceedings. I don't care if they signed a paper when they first started working with you that says, I promise I won't drag you into my court proceedings. They will. If they want you in court bad enough, if their attorney wants you in court bad enough, they'll get you there.
Oh, if they want information also, Dina, they'll write a subpoena. You have to respond to that.
Yes, they will. If you tell them, no, you promised that you wouldn't drag me in, the attorney will say, well, fine, here's a subpoena.
Yeah.
And to counteract a popular misunderstanding out there, subpoenas signed by attorneys are valid subpoenas. Subpoenas do not have to be signed by a judge in order to be valid. You need to understand that. That's a popular misconception, and I'm doing everything I can to change that. So tell your friends, subpoenas signed by attorneys are valid. Please understand that. You need to give them the same weight that you would one signed by a judge. 99 times out of 100, subpoenas are signed by attorneys. Very rarely are they signed by a judge or even a clerk. So understand that up front. Third thing I think you need to understand is as you're dealing with this process, and at the end of the day, at the end of the process of going through the care, all of those things, at the end of it, somebody's not going to be happy. Whether it was a couple who came to you trying to keep things together, one person says, nope, I'm done. I've had enough. I'm out of here. And the other person says, no, I still want to try. The person who still wants to try is not going to be happy at the end of the day because we're going our separate ways now. If you're talking about custody, one parent wants more custody. One parent wants to stop the other from having custody or visitation or what have you. The judge may side with them. The judge may not. Somebody's not going to be happy. You need to understand that. So how do you deal with all of those? This is tip number 4. How do you handle all of that? We come back to the topic that we've been talking about for the last 3 sessions together, which is boundaries. You have to set your boundaries. You have to set a code of conduct. Call it a behavioral contract, if you will. I don't care what you call it. I personally believe that if you write it down on paper and you have both parties to the couples therapy, or you have both parents to the child who you're treating, sign that document. Later, when they say, you didn't tell me that it was going to cost all this money for me to get records. You didn't tell me that you were going to charge $150 an hour for me to have you appear in court. You can drag out that piece of paper and say, yes, I did. Here it is, right here. You signed it. A signature is a powerful thing. Use it. It's important. Okay, so let's, excuse me, let's start the conversation. Let's talk about couples therapy first. 2 adults, they come to you. We want to try and work this out. We want to keep it together. Maybe it works, maybe it doesn't. And depending on your therapy, and please don't take any of my comments as making specific comments on how you do your practice, because that's not my intention at all. Excuse me, I'll give you some examples. If they fit, fine. If they're sort of close, that's fine. Let's say you're treating a couple and you have them in session together for 2, 3, 4 sessions, and then you decide you want an individual session with each one. And then maybe you have them together again, and then you have some individual sessions. And then maybe if there's children involved, you have one person and their child in to talk about parenting issues. Things like that, different combinations of people. You need to be, excuse me, you need to note in your documentation who's in the room. It's important because at some point, when this goes to divorce court, somebody's coming calling for those records. And just because you have two people who were in a session or who were getting couples therapy does not mean that both of those people automatically get all the records. That's important. If you have couples therapy, you need consent from both people in the room to release the records. That's important. Sometimes I talk to social workers all the time where this is happening. They've had couples therapy and they're in divorce court now, and one of the parties has gone to their attorney and said, yeah, we were in therapy. The attorney comes to you and says, I have a release signed by my client. I want all the records from the therapy. Your first reaction should be, my suggestion to you, your first reaction should be to reach out to the client that they say they represent and say, number one, do they really represent you? Number two, do you understand what they're asking me? Because they're asking for all the records and all the things that we discussed, even the uncomfortable things, even the things that you haven't shared with the outside world yet are going to be shared. Are you sure you want that? Once you've given that to the client to think about, you go back to the attorney and say, I'm sorry, I can't release records without consent from both parties. You get me a release, I'll get you the records. Put it back on the attorney. They get paid way more per hour than you or I ever will. Make them do the work, okay? If, excuse me, if that other party will not give you a release for the records, then the client whose attorney is asking, the only records you can release are the ones where the person was in the room alone with you. Don't release the ones with the child, because those are going to be off limits. Okay? Just the individual. If you get a release from both, mazel tov. Let them all have them. They can fight it out. It's not your job to worry about what the records say. It's not your job to worry about how that plays for one client or the other. It's the attorney's job. You just write your notes. You write your notes like you write your notes. If they're vague, they're vague. If they're detailed, they're detailed. I would suggest that when you have time and you have nothing better to read, pull up the HIPAA rule on the release of mental health records. The HIPAA rule is very specific about how it divides up records. And I apologize for the snoring in the background. It's my bulldog. Sorry about that. He's kind of loud right now. The HIPAA rule separates records into two different sections. Psychotherapy notes and progress notes. Okay, very two specific things. Psychotherapy notes you don't release. Those are intended to be yours. Progress notes is everything else. So read the rule and read through it. It's got a lot of good stuff in there. Okay, any questions? Because I know I'm kind of blowing through this kind of quick. And if you have one, go ahead and type it in the chat or raise your little hand or whatever. Okay. Again, at this point, I want to emphasize that you need to have those boundaries in place, because you don't want to have one of the couple coming into you and using you as a girlfriend or a boyfriend or whatever, as somebody that they can just rant about and assume that you're going to write everything down. And when they come get the records later, that you'll have notes of all of their stuff, all of their beefs against that other person. You don't want that. You don't want to be that person, okay? Remember the boundaries. Hold them to them. Okay. Let's talk children. Let's talk if you are, well, wait a minute. Let's back up. I'm going to go back to the adults. You are representing, or you are treating now one person, one half of the couple. They were never seeing you for couples therapy. You're only seeing the one person. And whether this is for the divorce business, whether this is for custody business, whatever, you need to be careful about your role here. You are in this as a therapist, okay? The question that I see, and I'll talk about this a little more with the children, the biggest question that I see is the question that you're asked, do you have an opinion on custody? Who wants to guess what the answer to that is? Helen, you're smirking, I can see it. You don't have an opinion on custody, period. You do not. Your role in this is a therapist, not a custody evaluator. You cannot be neutral in this. You haven't seen your client be a parent. You haven't seen the other person be a parent. You don't know anything about parenting skills, what they've got going on, none of that stuff. And if you give an opinion on custody when you don't know both sides, the other person's attorney is going to beat you to death. Plain and simple.
I wouldn't give an opinion if I knew both sides.
Good. Wise choice. Wise choice. It's dangerous. It just really is. So let's talk about treating children. Some of you may treat minors, whether they are small children, 4, 5, 6, or teenagers, 14, 15, 16, anywhere in between, combination of the above. In this particular case, you need to remember that you are the therapist for the child. Mom does not need to come in when she drops the kid off for therapy and vent her spleen about dad and how horrible he is, and he never pays money, and he's mean to the kids, and he does this, he does that. No, that's not part of the child's therapy. That's mom trying to pull you in on her side. Smile politely and say, thanks. I'll bring kiddo out when we're done. Okay. I have spoken, excuse me, I've spoken with quite a few social workers lately who are they're treating a child in the business of custody. And the child happens to be 16, 17, almost 18 years old. And these children they've had enough. They are tired of being the stick that the parents beat each other with. And there's usually one parent that they're angry at and they want nothing to do with. And that parent is dragging the other parent back into court. You're poisoning the child against me. You won't let me see my child. You won't let me do this. You won't let me do that. And all the time it's the kid saying, I've had enough. I've had enough. In those cases, I always suggest, especially when the two situations that I dealt with last week, the social workers had been subpoenaed to testify at a hearing. And their client was 17. They were within a year of being on their own. And the teens, the young ladies, both of them in this case, were extremely vocal about, I don't want to go see my dad. I want nothing to do with him ever again. I want nothing to do with him. And so the social workers were being dragged into a hearing where dad was accusing mom of poisoning the children against him. Bias. And I told the social workers that get a consent from mom to, even though they had a subpoena, I always suggest that you get a release authorizing you to testify at a hearing. It's just a little bit of extra cover. In case the hearing goes bad, you don't want to have a parent coming back at you screaming, why did you testify? You said it wrong. You did everything wrong. You blew this, okay? In these particular cases, I also told these social workers, talk to your client. Your client is almost 18. I believe that your client has a right to know what's going on. Talk to your client. Share that you're going to testify. Find out what that client really wants you to say. You are that person's voice in the courtroom. Don't lie. Do not exaggerate. Keep it as neutral, no drama as possible, but share that child's voice. Give that child a voice in the courtroom. I think it's important. Very important. One thing that you need to understand if you are treating children, no matter how old they are, and no matter where they're at in the divorce and custody process, you need to understand that it's never about the children, unfortunately. I'm a paralegal by profession. I am not a social worker. I spent the first half of my 30+ year career in a law firm until I came to the company where I work now. So I've seen a lot of courtrooms. I've seen a lot of lawsuits. I've seen a lot of claims. There's very few things I have not seen. And one of the constants in all of this, especially in family law, is that it's not about the child. It's not. It's about money. It's about power. It's about control. The child is caught in the middle. And so therefore are you, if you are treating that child. You need to do the best you can. Remember those boundaries. Hang on to them. Stick to them. Don't let them drag you in. If there's a battle going on between dad wants records and mom doesn't want to give them up, shove the battle back between the attorneys where it belongs. Tell mom, you two need to work this out. One of the questions that I get a lot is over consent. Parents have initially given consent for a therapist to treat their child. And then as they're going along, at some point, one of the parents, just to be mean, says, I withdraw my consent. You no longer have consent to treat my child. What do? Technically, you still have consent because you've got consent from one person. But what does the custody order say? Does the custody order say that both parents must agree? If that's the case, you've got to step back and make them figure it out. Now, if you've got a child in crisis, you can't step back. But if you've got a child who's basically okay and is just fed up with mom and dad, yeah, you can step back and say, okay, figure it out. When you get it figured out, give me a call. I'll work you back into my schedule. Okay? You want to stay away from this as best you can. Phil, do you want to talk about what kind of claims we've seen?
Yeah, I want to fill in some of the insurance part of it. This is an exponential powder keg is what we're talking about when there's therapy provided to divorcing spouses. It's exponential because there could be a child involved as well. If let me put it in simple terms, like a casino. If you walk into a casino and you're playing roulette, typically it's supposed to be an equal number of red numbers and black numbers. Well, if you put a bet down in this game and red means you're going to lose, probably 9 out of the 10, 90% of the time it's going to be red. You're going to lose. You're going to be in trouble. So in other words, go back to the root of your insurance protection. Take a look at, after this call, if you're practitioners, take a look at your insurance policy. If this is not an advertisement, I'm not trying to sell you an NASW risk retention group policy, but take a look at whatever policy you have. We cover you for this. We don't exclude professional services that relate to divorce and spouses going through a divorce. We cover you for that. Most carriers exclude it. And, they won't even give you a raincoat to keep you out of the rain. I mean, we give you coverage. There is one carrier, I'm not going to mention who it is, but there is one carrier that will charge you a large endorsement fee, but it's only for partial coverage with a really low limit. And you have to go through a lot of hoops and gyrations to even get that endorsement. You have to bring in an attorney. You have to pay for that yourself. And each spouse has to bring in the attorney in to be able to get that endorsement. I mean, they're making you jump through all kinds of hoops because they don't want to really sell it to you. And that tells you something. This is one of our most frequent and severe claims. And the reason I say it's frequent is because it initially boils down into a licensing board complaint. Dina said earlier that in her point number 3, somebody's going to be unhappy. You know, it's a zero-sum game. Somebody's going to win, somebody's going to lose in this kind of thing. And the loser is going to be met. They're the ones that bet on the roulette wheel and it came up red all the time. Okay, they lost, and they're going to be mad. So what are they going to do? What I see them do, and the first thing is they want to get back at you, and because you got in the middle of this and you took the other spouse's side, or it didn't happen the way they wanted, they're going to file a licensing board complaint against you. Okay. Now, what does that mean? Well, gee, it had to do with a divorce. I'm not going to cover you because it's excluded in my policy. Well, not in ours. We'll cover you for that. That's a $1,500 to $2,500 legal fee right there to respond to a licensing board complaint. Even though you're totally innocent, you got to respond. They subpoenaed you. And they also, for records probably, and that'll be in addition to the $2,500, but they filed a licensing board inquiry or complaint, and then that's got to be settled. You know, you have to investigate that. That's why I called this the mud-slinging battle, because it's going to spill over on you. No matter how well you define your boundaries, you're going to get stung. You're more times than not, you're going to get hurt. It's that roulette wheel that the wrong color keeps coming up and you get nailed. Another thing they do is just dissatisfaction. If they don't want to file, they will file a licensing board complaint because it makes sense as to get the lawsuit on the way. But they might take it a step further, and this thing could fester into a lawsuit from just a mere complaint into an incident and a full-scale lawsuit that they file against it for some kind of negligence. The plaintiff attorneys are very creative. They'll think up something to put up a list of complaints, and negligence is always at the top of the list. So you need to focus, go home, take a look at your policy. They're probably 25 or 30 pages long. Somewhere in there, they talk about professional services being rendered and what aspect of that is covered and what is excluded. That's the first thing you want to look at. Because if I was a practitioner, I would make sure I have that buttoned up, or I wouldn't practice, because I know I'm going to get nailed. I need that protection. And then the next thing, here's another thing that occurred, just to show you how trivial some of these complaints are. We had a brother who was being treated, a young man who was being treated by a social worker, and the brother, they were living together in the same house. The brother received a phone call from the admin, from the social worker, confirming an appointment. They didn't say what the appointment was for. They didn't even say it was a social worker. This is Dr. So-and-so wants to confirm the appointment. They got sued for that. We don't think it's going to go anywhere, but it was a lawsuit. You believe that? A lawsuit just for the brother of the patient, of the client, taking the message about the appointment time, because the disclosure was made that his brother was seeing a therapist, but he didn't even know what the therapist was, whether it was a foot doctor, a podiatrist, or a heart doctor, or a social worker, or a psychologist. So this is how vicious some of this turns out to be. If the other spouse can get you on anything, disclosure of information by accepting or taking a note that the husband, who's also the brother of this fellow who received the appointment, is being sued for that.
Yeah, that's Phil. Those are really, really good points. I talk with social workers at least once, maybe twice a week, whether it's and usually it's about a subpoena. They've been subpoenaed to court, yeah. And they have to testify. They don't want to. And as I go through and I share, I've got 7 things that I always share with social workers, kind of a way to help yourself get through all of this and process all of this. The last thing that we talk about when I'm telling them about testifying and the outcome, I always tell them, that to keep an eye out in the mail, in email, by phone, whatever it is, keep an eye out for something coming from the state licensing board. And I believe in New Jersey, you get a letter. I don't think it's just a phone call. I think you get a letter from the board saying a complaint's been filed against you. Your response is due in this many days.
Yeah.
Heaven forbid that the parent who drew red on the roulette wheel turn the camera around on themselves and see that they just suck at being a parent. And that's why they lost. I'm sorry. But these board complaints get filed for, I saw one where very recently, where a social worker wrote a letter for a parent to use in court. It was basically a treatment summary, but dad and dad's attorney took that letter and twisted it to try and claim that the social worker was biased against dad and for mom. And when that didn't work in the hearing, dad then turned around and filed a board complaint.
Yeah, yeah. That's a revenge factor, you know. They're darts coming, and they're arrows and darts coming at you the whole time.
And they're poison darts. They are poison.
If you don't have a shield, if you don't have a policy, a PLI policy, it's going to shield you. You're going to get stuck with a lot of holes in you.
Yes,
you know, and what does that mean? $1,500 there for the subpoena, $2,500 there for the board defense. You know, the board acquired defense. These legal fees add up.
Yes, they do.
And that's why our competitors took this out. They exclude this divorce-related coverage because it just got to too many times. It's a frequent claim, and at times it can be very severe, expensive.
It can, and you don't know where the board complaints are coming from. So yeah. Keep an eye out for them. Just because you get a board complaint, that doesn't mean you did anything wrong. Right.
Yeah. But even if you're innocent, you still have to pay your legal fees for defense.
Yes, you do. Because if you don't, and I have seen recently where I can't confirm that a social worker actually filed a response to a board complaint quite a few years ago. And now the licensing board, they're starting to work through the stack, and licensing boards across the country are buried in paper.
Oh yeah. It takes like two years to get these resolved now. Yeah, they've stacked up.
There are some boards that are 2 years plus behind. And so, I mean, they weren't moving with lightning speed before COVID, but since COVID, where everybody is now working from home, it takes longer to get things through.
Well, they had to close down for a while too, Dina, remember? Yeah.
Yeah, and so I've seen recently where a social worker had a board send him a consent order saying, because of the complaints that were on this complaint back here, and this is why I don't think she responded, or he responded, because of these complaints, this is the punishment that we're levying against you, which in this case is a fine, suspension, and a whole lot of continuing ed credits.
Yeah.
Don't risk that. Always, always, always respond to a board complaint, even if it's a crock.
Well, that's what I said. It's a powder keg, and that's what I said after this call, or the time that you have today, wherever your policy is, pull it out of your file. Whoever's covering you for your professional liability, read through your policy and see whether or not you're covered. This is your biggest risk if you're providing any sort of counseling with respect to spousal issues.
Well, and one of the other things to remember is, don't think that you're immune from winding up in court just because you don't treat people involved in divorce or custody, or because you don't treat children. Anybody can take you into court. I talk to social workers all the time where they say, my client didn't tell me they were involved in litigation over a car accident, and now they want my records. What do? Give them the records. They got a release, they got a subpoena, they got whatever. it's been properly done, give them the records.
You could also get hauled in just for a curbside counsel.
Yes.
Just you run into somebody on the street, you know, doing a shopping mall, and the subject comes up and you're mentioned.
Yeah. You never know. So just be aware. Just be very aware that all of your work does not happen in the therapy room. There's other places where you're going to get stuck. Okay. You need to have your eyes on that.
Right. Thank you. Any questions? Quite thorough.
And one of the things that and our other colleague Lonnie Rock, who is with underwriting at NASW Risk Retention Group, can't be here today. But one of the things that she asked that we remind you, kind of tagging in behind what Phil said, read your policy and understand that when you have that policy, know what you need to do in order to trigger the policy. Just because you have it and you paid the premium doesn't mean that things magically happen. You have to affirmatively report things. And the quicker you report things, the quicker we can get the experts that you need involved to help you with this. Helen, I need to step away for just a second.
Yeah. I mean, you've always been very receptive. So, you know, people who have policies can call, right, Phil?
Yeah, they can call the helpline anytime they want. I would also point out from a cost benefit relationship, our average policy in the risk retention group is $230 a year. And that's for 1 million up to 5 million coverage, but mostly we sell 1 million, 3 million in limits. And our average claim is about $3,800. And so, you know, it's really a no brainer. I'm not trying to be a commercial for our product, but I bought a policy myself. I'm a believer in it. And we don't have an exclusion for this risk. You know, everybody else does.
Can you give the website out? Can you say the website address?
I guess you could just type in Assurance for You and buy one on the broad market. You know, or go to the NASW site and then you can toggle over to the ASI.
Isn't the website NASWASI.org?
Yeah,
that's one of them. We have a lot of different addresses.
Yeah, I see NASWassurance.org. I'm going to put that in the...
Thank you.
Why we're doing this is, as I said this on the previous calls, we're not owned by Wall Street investors. We're owned by the policyholders. Whoever buys a policy owns the RG. So it's a mutual insurance company, and the profit that we make doesn't go to dividends to pay Wall Street investors or anybody. It goes right back to benefits in the policies for the policyholders, and it lowers the premium. We keep a premium that's really low. Some of our premiums are a third what competitors charge, and our benefits are much more comprehensive. That's because we're a risk retention group. And you might say, well, what's that mean? Is that bad? I said, no, we're reinsured by Swiss Re, which is the largest reinsurance company worldwide. And you know, we don't even want to bother with state guarantee funds because they're puny. They only go up to a couple $100,000 if a carrier goes bankrupt. Well, we're not going to go bankrupt. We're an AM Best excellent rated carrier. Even though we're little, we're excellent rated, and we're backed by Swiss Re. So, you know, we've covered all the bases for our members. We've been doing this 9 years now, and we're very successful. And for the policyholders.
Phil, we got a question in the chat from Chris. I get a lot of calls from social workers for advice. She's also an attorney. I usually refer to the insurance company, even if they suspect there may be a malpractice issue, because it's usually required for coverage.
That's right.
Yes. Yeah.
Yeah. We have the right to pick the attorney for the defense, because we rely on Gallagher Barrett's network. You have about 300 attorneys in your network, and they're specialized in allied health. So we put the case out to them first.
And part of the trigger for the coverage, as Chris suggested, you got to tell the insurance company. It doesn't happen in a vacuum. And you need to report it right away. If you get a licensing board complaint, if you get a subpoena, if you get a request for a deposition, if any of those things.
That's called an incident. Dina, we call that an incident, and then we have to determine whether that incident is eligible to be called a claim. Is it in fact covered under the policy contract?
Yes.
And so that's why you got to get to us right away, so we can figure that out.
The other reason to get it to us right away is there is usually a time frame.
Right.
You have to respond, and responding late doesn't work well. You can wind up, especially with a subpoena.
Yeah.
Because if you've got cranky attorneys, if you've got cranky judges, any of that kind of thing, if you respond late or don't respond at all, you can wind up subject to a contempt of court citation.
Yeah, that's why I called it an exponential powder keg, because it has a burning fuse, and it'll blow up in your face if you don't respond.
I had a conversation with a social worker, I guess it's been probably 5 years ago now, who had gotten a subpoena from an attorney, and she determined all on her own that because she was no longer treating the child of the divorced people who were battling over custody, that her testimony was not relevant. And so she ignored the subpoena. She did not show up for the hearing. At that point, the attorneys filed a motion for contempt and cited that they had properly served the social worker with the subpoena and given her plenty of notice to get whatever counsel she needed, to get whatever information she needed to show up, and she chose not to show up. And the judge agreed with the attorneys, and the next document that the social worker received was an order for a show cause hearing, saying that she had to show up. She had to explain why she didn't show up for the hearing the first time, and she had to pay the attorney fees for both attorneys who had shown up for the hearing before that she chose not to. Yeah. She was looking at probably $1,000, $1,500 in fines before the judge issued a fine. And she called me and said, "What do I do?" I said, "You go to court. You've got an order from a judge. The judge has signed it. Go to court." No.
And add attorney fees on top of that.
Yeah. I said, she said, "My testimony is irrelevant." I said, "How do you know?" She said, "Because I don't treat the child anymore." I said, "Well, obviously the judge doesn't think it's irrelevant. The judge wants you there. I suggest you show up." "Well, I don't want to." I said, "All right, fine. Don't show up. Don't show up." She said, "Really? I could just not show up?" I said, "Well, yeah, you can just not show up. And then don't be at all surprised when the sheriff comes and puts the pretty silver bracelets on you, stuffs you in the back of the car, and escorts you to court." She said, "They can't do that to me." I said, "Oh, yes, they can. And they will. Don't push it." Now, that's an extreme case, but please don't go there. If you get a subpoena, call. If you're an NASW risk retention group insured, call in. Call the hotline. I'll talk you through it. I will tell you my 7 steps to successfully do this. Chris also had a comment And thank you for these, Chris. I appreciate that. Subpoenas from attorneys, yes, they're real, but the social worker should assert privilege first, agree via a letter if there is no HIPAA release or any question about the validity. I do tell social workers that, yes, you want to try and protect your client as best you can. Some social workers attempt to work things out with the attorney and ask them if they can present a treatment summary instead, or explain that there is some significantly personal information here. And I have been very surprised lately. What I think is a wild out there thing that has been discussed in session is not so wild and out there. I've talked to social workers who are treating teens where teenagers came into session and they have shared that the teens are questioning gender. And they're just trying it on. They want to see if it fits. They don't know if that's how it really is, but they haven't shared it with anybody else. The social worker that I'm thinking of that I talked to about this, she was treating the child. The parents were battling over custody. One of the parents was extremely Christian and extremely conservative. How do you think a gender question is going to play for that parent? All of a sudden, it's going to be, you're poisoning my child's mind. You can't have access to the child anymore. I want this child with me. I'm going to get the brainwashing out of here. You know, all of this kind of stuff. You don't want to release those records with that kind of stuff. See if you can come to some sort of terms where you can withhold the privilege. Fight it. Try it. Absolutely. I agree with Chris. Try it. But understand that at the end of the day, if the judge orders, thou shalt give up the records, thou shalt give them up. Talk to us. We'll see. We will get some attorneys involved to see if there's a way that we can quash the subpoena or get it protected as best we can.
Yeah, I've seen a few cases, Deanna, where they subpoena records because they're like a torpedo looking for a target, a torpedo in the water. It's already been fired and it's looking for a ship to slam into. So they issue a subpoena. They want to get a hold of the notes. They want to see what was said with respect to the child, whether the opinion of the social worker was put into the record, where the social worker advocated for one of the two spouses to be a better parent, and then they catch them in that. And that's when you have a real problem.
Yeah. I talked to a lot of social workers who they deal with drug and alcohol issues. And that kind of information is protected by federal law. 42 CFR something, something, something. They can rattle off the numbers right away because they know what the federal statute is that protects drug and alcohol type issues. If you are a person who works with those, please spend a little money, consult with an attorney directly. Find out what your options are. I always say it's probably the best couple $100 you will spend. An attorney will sit down with you and explain, these are your options in this state, in these jurisdictions, because each court is different. Each court has different rules. Each county has different rules. Understand what the rules are where you are. Spend a little bit of time, or if you've got a good friend who's an attorney, buy him dinner and say, hey, talk to me about subpoenas. Explain to me what my options are. When I get a subpoena, what can I do? How do I file a motion to quash all on my own? Social workers do it all the time. If you know the proper language to write that motion to quash, you can certainly try it. Full disclosure, I have been told by attorneys in many states, including New Jersey, that there's give or take an 80–85% chance that a motion to quash will not be successful. But try it. Show the client, show everybody that you are doing everything you can to protect that client's confidentiality. Any other questions that we can answer? Phil's advice was good. When you have a minute, pull out your policy, no matter who the carrier is. Pull out your policy and read through it. See what it covers. Importantly, see what it doesn't cover. See what your limits are. Some policies for licensing board complaints, I think the standard coverage for NASW Risk Retention Group insurance is $35,000 for a licensing board complaint.
Yeah, you can buy additional layers, but
you can buy additional, but I think that's the
I don't think you need more than that.
There are policies out there that I have seen where the coverage for a board complaint is $5,000. That doesn't cover much. Read your policy. It's important.
Yep.
That's one of the best defenses that you can have for everything.
Brilliant.
Questions from Facebook or anything else we can talk about?
Well, it's been delightful helping you all the past 4 sessions.
It's been lovely having you and having the access that's in this. It's just brilliant. So, and you're absolutely lovely to work with. So really appreciate all you've contributed. This session will be up on our YouTube channel within the next couple of hours. So if you logged in late or you missed something, it'll be available. If there's no questions, you're going to get 8 minutes back in your day. So
you can read your policy.
Yeah, use that 8 minutes to read your policy.
Yeah,
Right? So, but thank you so much, Dina and Phil. We really appreciate it. And thank you everyone for making time in your day to come and join us.
Thank you. Bye-bye.